One of the hottest current topics is what we should do with those foreign nationals who commit violent acts against the United States. We'll talk about the trial of a terrorist right now on The Law Works.
From West Virginia Public Broadcasting.
The Law Works is made possible by the generous support of the West Virginia State Bar and the Monongalia County Bar Association.
What are the considerations involved in trying people we consider terrorists? What is the worldview? My guest is West Virginia University law professor Jim Friedberg. Jim, thank you for coming back.
Great to be here, Dan.
You've been our international law resource for a number of years, and I always enjoy talking to you. Well, we're talking about Khalid Sheikh Mohammed and some others that have been identified as being involved with the September 11th attacks on America, specifically the attack on New York, and we want to do something with them. Attorney General Eric Holder has decreed that they be tried in the civilian criminal courts and specifically in New York City. But there are options, including military tribunals and I suppose an international court of some sort. How do we decide what we do with these people? Is there some law that applies to it?
Well, I think the law sets minimum standards. When you have somebody in your custody, international treaties that we're a part of, international customary law says that these people are entitled to a certain amount of due process, that they're not permitted to be mistreated. But beyond that, there is a fair amount of leeway as to where we try them. Wherever we try them, we have to give them fair process and a chance to make their case.
I know that we in the United States become angry, outraged, incensed when our citizens are taken into custody in other countries and then we're told that they're going to be held for trial for whatever it is they are alleged to have done. There have been trials recently in Italy of a young American woman who was accused of murder. That was a civilian trial. There have been trials or threatened trials in Korea, in Iran, for people who we say inadvertently crossed a border or who accidentally looked the wrong way or something like that. But when it happens here, we take somebody into custody, we seem to get them in a variety of different ways, and then we're stuck with trying to figure out how to treat them. For example, the people that are going to be tried in New York are said to be members of Al-Qaeda, and I think they say that they are. But what's Al-Qaeda? Is this an army of some foreign government, or is this just a collection of people who have an agenda?
It's more of the latter. It's more a collection of people that have an agenda. It happens to be what we would probably consider a terrorist agenda. That being the case, those folks are not covered by the main body of the Geneva Convention that deals with prisoners of war. The reason is that prisoners of war are folks that are combatants in regular armed services of a particular state. That cannot be said about most of the Al-Qaeda prisoners. I suppose those Taliban fighters that were captured while the Taliban still ruled Afghanistan in the very early months after 9/11, they might be considered Geneva Convention covered, particularly if they were captured in uniform.
Well, you're kind of approaching then one of the threshold issues that gets involved in all this.
Let me just make one other point.
Okay.
But to get back to your earlier question, the question that started our discussion, how do we decide? As long as we're meeting the international minimum standards that I referred to, that decision as to where to try these people ends up being more of a political decision. What is the best policy than a legal decision? The legal part of it seems to be the floor. But if you have more than one option, then it very well may be a political choice and not really a lawyer's choice.
Political choice among what body politic? Internal to the United States, or among our allies, or on the full international stage?
Well, since they are in our custody, the political choice is primarily a political choice by our government, our President, Secretary of Defense, Secretary of State, Attorney General. Those folks have their input as to whether somebody ought to be tried in Guantanamo, in New York, by a military commission, by a civilian court, what particular federal district, etc. It may have a political impact on how we're regarded by allies and non-allies and international organizations, but the power, the political power to make the choice is our federal government's.
You've got a box of snakes there. And we could probably spend a week talking about all the nuances of it. Let's go back. We were talking about enemy combatants, who they are and who they aren't. Are members of Al-Qaeda a non-government body, a non-government army, apparently, or a collection of people with a common agenda? Are they truly enemy combatants?
Well, as far as I understand it, the term enemy combatant does not have clearly defined legal significance. We heard it most frequently in the 8 years of the Bush administration, when the Bush administration did not want to classify these people as prisoners of war, because as prisoners of war they would be entitled to certain rights, especially procedural rights under the Geneva Conventions, which we are party to, that the Bush administration didn't want to give to them. It seems to me that anybody that's an enemy and is fighting you is an enemy combatant, but that's a common sense definition, not a definition that flows from any treaty or any statute that I know of.
It's a term of art, then, in the international legal community?
I think it's an inartful term that doesn't have much legal content.
Well,
prisoner of war has legal content.
But even at that, I recall during the Vietnam War, if our soldiers were captured sometimes, or certainly our pilots were shot down, they were taken into custody, and the North Vietnamese government declared them to be war criminals, not prisoners of war, not enemy combatants, and treated them accordingly. Now, in the 21st century, it seems to some extent that we're doing the same thing with the people that we capture. We're saying you're more of a criminal, war criminal, or something like that, than you are an enemy soldier. And there's no government sponsor, at least no overt government sponsor.
We have three categories now on the table that you've mentioned. Prisoner of war, enemy combatant, and war criminal. And those are not three independent categories. There's a lot of overlap there. So to take your North Vietnamese example, take Senator McCain, for instance, who was in a North Vietnamese jail and apparently badly mistreated for a long time. If the North Vietnamese captured him as an enemy flyer and said he's a war criminal and then tortured him, they are still breaking international law. While he may or may not have been a war criminal, he was clearly also a prisoner of war. A prisoner of war who has committed war crimes might be a war criminal, but that's for a court to decide. And no court ever decided that McCain was a war criminal.
I don't even think it was particularly alleged by anybody except one or two guards.
And furthermore, the penalty for being a war criminal is not to be tortured, it's to be sent to prison. The North Vietnamese were breaking the law when they were mistreating them like that. He was entitled to Geneva Convention treatment, and he did not get it. Al-Qaeda, on the other hand, is probably not entitled to the full panoply of Geneva Convention rights, because Al-Qaeda is not a state. The fighters for Al-Qaeda tend not to be in uniform, so that they do not meet the criteria to be protected fully by the Geneva Convention. However, whatever enemy combatant type they are, they are protected by one particular aspect of the Geneva Convention. It's called Common Article 3. There are 4 Geneva Conventions. All of them have this same article in them. And this Common Article 3 essentially says, no matter what the status of this war, whether it's a guerrilla war or a war between states or a revolution, anytime there's significant armed conflict in a state, there is a minimum standard below which no government can go with people that it gets in its custody. And that includes things like serious abuse, mistorture, ravaging the civilian population. You never can do that during a war, no matter who you are and no matter whom you're doing it to. So if anybody was mistreated, for example, in Guantanamo or Abu Ghraib, that's a violation of Article 3 of the Geneva Conventions, even if they are not otherwise military of a regular sense that are protected by the conventions. And that's going to go into these issues that you started with concerning where should we try these people. There are some folks that are worried about getting them into civilian American court because we have more procedural rights and protections once you're in a civilian court on the American mainland than might be available in a military commission in Guantanamo. And when you start raising this kind of mistreatment as perhaps a reason that evidence shouldn't be taken, there's a worry, I suppose, that you might not be able to convict these folks because you might not be able to introduce the evidence and keep it in.
In a civilian court.
In a civilian court. Now, I don't know exactly how much more leeway you would have in a military commission because there's not as much history behind these military commissions. We don't know how things are going to play out, if they play out at all, under the new military commissions law.
Military commissions, in the present day sense, are a fairly new creature, although we have had military tribunals and things labeled military commissions back many, many years, and probably the most famous ones were the Nuremberg trials at the end of World War II. Those were, in fact, military trials. And you would have a panel of judges and things like that. And it's really beyond the scope of this program to talk about the procedural differences between military commissions and civilian courts. And for one reason, because the procedures aren't clearly defined in the military commissions. I suppose there's some sense of, let's give him a fair trial, then hang him in a military commission sense, and that's not so clear in a civilian court.
There's another distinction which goes a little bit beyond my envelope of expertise from international law into the area of constitutional law that should be kept in mind here. Our Constitution is generally thought to be territorial. The U.S. Constitution and all its rights, equal protection, no cruel and unusual punishment, due process, are thought to run to the edges of our geographical boundaries, from the Atlantic to the Pacific, from Canada to Mexico, and into Hawaii and Alaska. The Constitution generally is not thought to run beyond that to protect people. So bringing a trial to New York means that pretty explicitly the government cannot claim that this particular person does not have this constitutional protection because he's sacrificed it or because he's a terrorist or anything like that. All the normal procedural protections of the Constitution go to this person if he's tried in New York City. If he's tried outside the United States, you're going to have lawyers arguing in either direction.
One of the rules that apply to constitutional rights is that if you're in the United States, it doesn't matter who you are, and it doesn't matter why you're here. If you're here legally, illegally, if you're a citizen of the United States or you're a citizen of any other nation, if you are here, you're entitled to the full protections of the United States Constitution. And I guess one of the arguments is that gets in the way of a fair trial.
Well, hopefully it doesn't when the prosecutors have not totally screwed up beforehand. To take a civilian situation, let's say the Cincinnati Police Department beat somebody up to get a confession. well, if they do that and then they go into court in Ohio on a murder trial, it may be that the entire case is lost.
Because the confession can't be admitted.
Right. We don't know how this kind of dynamic would play out in terms of trying a terrorist that was mistreated. It's a clean slate. There are not any clear, on-point precedents that are going to tell us exactly what's going to happen when you bring somebody who's been waterboarded 30 times to a federal court in the U.S. and say, well, we have all this other evidence against him. We're not using the evidence that we got when we waterboarded him. It's going to be up to the judge to say, okay, we can build a firewall around the tortured evidence and still go on with the trial. But one does have to consider, is all the evidence so tainted by the mistreatment that the person could be found not subject to trial? I think that's really unlikely. I think that judges can take into consideration in balancing these things all the circumstances and the horrendous nature of the crimes that happened against the United States in 9/11 and elsewhere.
But we have threshold questions.
And isolate the evidence.
If the Cincinnati police beats a confession out of a suspect, we can be pretty sure that the judge is not going to admit that statement, that confession, into evidence. But we have had raging debate over the years, you mentioned waterboarding, about whether waterboarding is actually torture, whether it's a figurative beating of a confession out of somebody. So we're going to have to make that initial decision. The judge is going to have to make that threshold decision as to whether or not waterboarding or positional discomfort or stress or whatever they call it, or deprivation of sleep, deprivation of food or water, constitutes a coercive extraction of a confession from a suspect.
I think you may be conflating two different questions there. There's the question of what's torture, and there people might debate on whether waterboarding is torture. I certainly think it is. I think most international lawyers that have read the Torture Convention think it is. However,
most people who have been subjected to it tend to say that it is. You're referring to McCain.
It seems to be a clear majority, but not perhaps unanimity, that waterboarding is torture. So there are some lawyers, principally those associated with the old Bush administration, that think it's not. However,
but it is fairly debatable.
Okay, yes. However, the second question you're asking, and I think this is the one that's separate, is an evidentiary question, a criminal law question. Is the evidence you are about to introduce reliable? Regardless of whether waterboarding is torture under an international law definition or an American law definition, I think we would probably agree that evidence obtained from waterboarding is not reliable.
Why is that?
Because it's coerced. Something might be coercive but not rise to the level of torture. And
that's a good distinction, yes. Congratulations. I had overlooked that. The issue here is one of reliability. If someone makes a statement, then you always have to test that statement to see if it's believable, if it's incredible. You've heard people say when they hear something, that's incredible. Literally, that means that is not worthy of credibility. That is not something that we can believe without testing it or having other evidence to make sure that it is correct. So when somebody makes a statement under torture, the question is, did they make the statement just to cause the torture to stop, or did they really mean it?
Or the non-torture waterboarding to stop, or whatever.
Or anything on the fringes of all that, yes.
Here is what would seem to be the solution that would be desirable if, as my contracts teacher used to say, I were czar of the universe. I think it gives a lot of international political credibility and a sense of a just and legal society for us to try these folks in the American system, in American courts, for the wrongs they have done. There seems to be overwhelming evidence that there are wrongs involved. I would hope that under the circumstances, the federal courts would develop a jurisprudence that would say these cases are extraordinary. We are not going to accept any evidence that is the product of any kind of mistreatment, but we're not going to throw the cases out because of mistreatment. If you have other evidence not obtained through mistreatment that these folks were part of a conspiracy to dupe terrorist acts, then we can go forward with the case. That in these particular instances of fighting extreme terrorism, while we will not accept tainted evidence, we will not support torture, we will not support mistreatment of prisoners, any evidence that you can bring forward that independently shows that these folks have planned to do these terrible deeds, we will accept in. And I think under those circumstances you would probably get convictions of those people that deserve to be convicted.
From my readings of concerning all people who are involved in these cases, the presumption of guilt is just huge. Everybody seems to believe that they have done what we believe that they have done, based in some part on extrinsic evidence and some part on their own statements. And it seems like everybody believes that convictions are a virtual certainty. The big fear is if we put them to trial in a civilian criminal court, we'll be giving them a forum in which to make outrageous political, militant statements about the United States, and we just don't want to hear that. The political sense is we don't want that to happen.
I have three responses to that. First, again, Dan, this is more in the realm of politics than in law. Second, judges have the power, as you know, to arrange what they do in their courtrooms. Just recently, in a different area, in the trial concerning gay marriage in California, there was the issue of whether the proceedings could go onto the internet, and it went to the Supreme Court. The Supreme Court said, no, we think publicity through the internet is inappropriate here because it would have a negative effect on the freedom of those that are testifying.
And that's in spite of the fact that the trial judge actually was willing to allow the coverage.
Right. Apparently the Supreme Court overruled the federal trial judge. Well, this is the kind of management that a court can do. If they feel that it would be an inappropriate platform to televise and web broadcast an alleged terrorist venting against the United States, they can run it the way trials have been run for centuries. It's a courtroom. There can be news people taking notes, but there aren't going to be microphones and there aren't going to be television cameras to turn this into a circus.
And additionally, the trial judge has a great deal of discretion over what's actually talked about in the courtroom.
I think I had a third point, but I can't. I used to remember my third points better when we started this series.
Well, if it comes to you in the next couple of minutes, bring it up. You're talking about the conduct trial. I have been told on many occasions by judges to stop that. I thought it was an important point. I thought it was a relevant point. The judge says no, and you stop.
If I were a judge, I wouldn't allow a television camera in the courtroom if you were the attorney, I don't think.
Well, if I were the judge, I think television coverage is great, and in fact, it's increasing a bit. Well, we've got just a few seconds left here. Is he going to get a fair trial in a civilian courtroom, Sheikh Mohammed?
I think if he has access to his choice of defense attorneys, and if he wants a fair trial as opposed to wanting to turn it into a happening, a
circus.
A circus. that it is possible to pick a fair jury and have a judge that gives him his procedural due process and eliminate those elements of evidence that were not fairly gathered.
Professor Jim Freeberg, thank you very much. Thank you also for being with us this evening. On behalf of the Law Works, I'm Dan Ringer. Good evening.
If you want to know if you need a lawyer, you can discuss your problems with a lawyer by calling the West Virginia State Bar Helpline, toll-free, Tuesday evenings from 6 to 8 at 1-800-642-3617. On the LawWorks webpage at thelawworks.org, you'll find a listing of recent The LawWorks show topics, information on how to obtain copies of the programs, and additional information about this show's topic. You'll also find a list of legal resources that can help you answer your legal questions. If you'd like to recommend this program to a friend, you'll also find video of this program on thelawworks.org. If you would like to suggest a topic for a future The LawWorks show, or if you're a school teacher and would like to receive a copy of this program for classroom use, please send us an email to thelawworks@comcast.net.
The Law Works is produced in cooperation with the West Virginia State Bar, the Mountain State Bar, and the West Virginia University College of Law. The Law Works is made possible by the generous support of the West Virginia State Bar and the Monongalia County Bar Association.
From West Virginia Public Broadcasting.